Welcome everyone to the Richard Cooper Memorial Lecture for 2022. For those of you who don't know me, you clearly haven't been reading the Forbes 500 Rich list lately or paying attention to the cover of Men's Health magazine. But my name is Rick Bigwood, and I hold the Sir Gerard Brennan Chair of Law at the TC Beirne School of Law at UQ, and I'm also the Dean there. Before proceeding any further, I'd like to pause to acknowledge the traditional owners and their custodianship of the unceded land upon which we meet this evening. These are the people of the Yagara Nation and the people of the Turrbal Nation, both of Meanjin, which we now call Brisbane. I pay my respects to the elders past, present and emerging, and extend the same respect to other Aboriginal and Torres Strait Islander peoples attending here this evening. I acknowledge the contemporary Queensland First Nations community who continue to maintain their identity, culture and Indigenous rights. We recognise their valuable contribution to Australian and global society. I'd also like to acknowledge the attendance this evening of the Honourable Justice Sean Cooper of the Queensland Supreme Court, who was the son of the late Richard Cooper, in whose honour this memorial lecture series was established. By way of background, the annual Richard Cooper Memorial Lecture is a joint initiative of the UQ Law School and the Federal Court of Australia. And so I'd just like to acknowledge that and to thank the court for this ongoing partnership and also for the provision of this wonderful venue tonight. The series was established in 2005 in honour, as I just said, of the late Justice Richard Cooper of the Federal Court of Australia, who passed away suddenly on 14 March 2005. The series is dedicated to the strong interest in maritime and native title law that Justice Cooper developed over the course of a long and distinguished legal career. Unfortunately, Justice Cooper's widow, Penny, and other son, Ben, are unable to attend this evening, but nevertheless send their best wishes and appreciation for the law school's continued support of Justice Cooper's memory through both this memorial lecture and the Richard Cooper Scholarship, which is administered annually by the school. My next task is to invite the Honourable Justice John Logan of the Federal Court of Australia to the lectern to introduce our distinguished speaker for tonight. I'm delighted and would like to extend my personal gratitude to our speaker for so graciously accepting my offer to deliver the lecture despite his incredibly busy schedule.
Justice Cooper, Chief Judge Devereux, my recently retired colleague, the Honourable Andrew Greenwood. So recent, it's hard to believe he's retired, but here he is. I envy that, particularly today, as I'm just embarked on a trial which was hitherto on his honours docket, and it's something of a gut-wrencher. Members of the Academy and the practising profession, ladies and gentlemen, without further ado, Mr. Nell.
Thank you, Judge. Your Honours, Your Ex-Honour, distinguished guests, ladies and gentlemen. I too wish to acknowledge the traditional custodians on the land on which we gather both physically and virtually, those watching the recording this evening, and pay my respects to their elders past, present and emerging. It is a great honour and privilege to have been invited to deliver this year's Richard Cooper Memorial Lecture. I first met Richard whilst I was working as a junior solicitor in London in the late 1980s at Hill Dickinson, coincidentally the solicitors for the owners in the Alkeon, the case I'm about to talk about. Whenever an Australian lawyer visited the firm, it was the firm's invariable practice to wheel out the resident Antipodean lawyer for that visit, presumably to act as a translator. Indeed, on that occasion, as Richard had been invited to attend the partners' lunch in the boardroom, a spread that was reputed to rival that of any London restaurant at the time, I was also invited to partake, an invitation that was not usually extended to junior solicitors, especially those from the colonies. By the time that I returned to Australia, Richard had been appointed to the bench, and I therefore didn't have the opportunity to work with or indeed against him. However, I did appear before him on several occasions when he was on the Federal Court. My last appearance was in Tysand versus the owners of the Cape Morton, a hearing before a full court of the Federal Court comprising Richard, now Chief Justice Alsop and Justice Ryan, on a case that deals with the meaning of owner and ownership for the purposes of the Admiralty Act. Sadly, Richard's untimely passing occurred before judgment was delivered in that case. But whilst Richard was not able to contribute to either the outcome or the judgment, at least directly, his contribution to Australian maritime and admiralty law as a judge and practitioner, a part-time lecturer of the University of Queensland, and through his association of organisations, amongst others such as Millans, was nevertheless significant and enduring. As I said, it is a great privilege to have been invited to speak tonight about an area of Australian law in respect of which Richard was a major contributor, and in honour of his contribution to that area of law. As you will have seen from the flyers, presumably, the issue that I propose to address this evening is dealt with by the English Court of Appeal in the Alkeon in 2019, and which was the subject of some academic commentary at the time. In that case, the Court of Appeal and also Justice Tier, at first instance, had comprehensively rejected a perhaps unorthodox application by a shipowner for an order that the plaintiff who had arrested that shipowner's ship provide an undertaking as to damages in order to maintain that arrest, and that in the absence of such an undertaking, the ship be released from arrest. An earlier proponent of the relief sought by the shipowner in that case, former UK High Court Judge Sir Bernard Eder, wrote of the Court of Appeal's judgment and also of Justice Tier's judgment earlier that, quote, "It highlights once again the fundamental injustice of English law concerning the arrest of ships and the urgent need for change." But not all commentators shared Sir Bernard's view. For example, Professor Tettenborn concluded that the result in the Alkeon was, quote, "actually correct and welcome," unquote. This was for three stated reasons, for which Professor Tettenborn concluded, quote, "In short, any hardship caused by the denial of protection to an arrest victim is largely theoretical rather than practical, and more than balanced by the need to ensure the efficient enforcement of maritime liabilities," unquote, a need to which I'll will refer a little later. Professor Martin Davies, Professor of Maritime Law at the Tulane University and a well-known friend of this jurisdiction, has also written in support of the current position and the position endorsed by the Court of Appeal's judgment. I'm sure that has nothing to do with the fact that the Court of Appeal quoted with approval some of Professor Davies' writings on that issue. Whilst the Court of Appeal's judgment has since been cited in the UK on several occasions, this has not been so much in the context of the issue at the heart of the case, but more for those statements by the court of the existing and established position and the practices under English law. To the Admiralty lawyer, if there is such a beast, the outcome and reasoning of the Court of Appeal's judgment in the Alkeon is plainly orthodox. Indeed, they might wonder what all the fuss is about. But to the non-Admiralty commercial or equity lawyer, of which I gather there are some, especially one familiar with injunctions and freezing orders, they may be puzzled by the outcome, and in particular how it is that a plaintiff can keep an income-producing chattel under arrest and not earning income for the duration of the litigation and pending the court's final determination of the plaintiff's substantive claim, without having to provide, in favour of the owner of that ship, any undertaking as to damages, and with no real liability to the ship owner if its claim is ultimately unsuccessful, and with only a very limited liability for wrongful arrest. Following the Court of Appeal's judgment, Sir Bernard Eder wrote, quote, I would challenge any right-minded lawyer to say that the present law and practice in this jurisdiction, that is England, is satisfactory," unquote, a law and practice that also applies in Australia. The inference perhaps being that an Admiralty lawyer who finds the current position and the decision of the Court of Appeal orthodox is not a right-minded lawyer, nor indeed would it seem Justice Tier and the members of the Court of Appeal. Sir Bernard's call for an urgent need for change has gone unheeded in England and elsewhere, and the issue has fallen away. It's an issue that's not been the subject of consideration by any Australian court, nor, so far as I'm aware, has any party to a proceeding in Australia attempted to agitate this issue here, let alone sought an order of the same type that was sought in the Alkeon. Although the issue was briefly addressed by Justice Brian Tamberlin, formerly of this court, in a paper that he delivered at the Millans Annual Conference in Canberra in 1999, to which I may refer again. It's in these circumstances that I wish to explore in this address whether the current position in which a plaintiff arresting a ship is not required to give an undertaking as to damages, in contrast to the plaintiff seeking an interlocutory injunction or a freezing order, ought be reformed, and if so, how that might be done and achieved, although I suspect that time will prevent me from addressing the last two questions. In relation to the Alkeon, I don't propose to discuss the judgments or the case at any great length. I simply just make some preliminary observations by way of background. The facts of the case can be stated shortly and are taken from the Court of Appeal's judgment, paragraphs 6 and 8. In early 2015, the plaintiff bank loaned $15.7 million to the owners, which was secured by a first preferred mortgage over the owner's ship, the Alkeon. In March 2018, the bank informed the owners that the ship's market value was $15.25 million, representing a value to loan ratio of 112% of the amount outstanding on the loan. That was less than the 125% value to loan ratio that was required by the mortgage. Accordingly, the bank asked owners to provide additional security in the sum of $1.75 million. In terms of the figures, it seems, in terms of the outcome, it seems a small sum now. Owners disputed the valuation and provided a higher one. Unsurprisingly, owners didn't provide the additional security. In April 2018, the bank issued a notice of an alleged event of default based on the non-compliant VTL and failure to remedy it. And by June of 2018, sent a notice of acceleration declaring the whole loan immediately payable, as well as simultaneously commencing an in rem proceeding against the ship and arresting it upon its arrival in Newcastle in England. At the time of her arrest, the amount that was said by the bank to be outstanding under the loan was of the order of $13.5 million. Owners denied that there'd been an event of default. They denied that the bank was entitled to accelerate the loan repayment and disputed liability for the full amount claimed. They also disputed, as I said, the bank's valuation, and there are some other issues. In July 2018, owners applied for the release of the ship from arrest. That application was heard by Justice Tier on the 23rd of July and judgment delivered on the 31st of July. The application for release was not accompanied by the usual offer of security, as is consistent with the usual practice, to which I'll refer shortly, but which in this case, as you'll appreciate from the figures that I've given, would in effect be an offer of providing security for the whole amount of the disputed loan. One suspects that if the owners could have provided security in that amount, they just would have repaid the loan. Owners, in support of their application to the court, the owners, in support of their application to the court for the release of the ship from arrest, said that they couldn't obtain a P&I Club letter of undertaking to secure the release of the ship from arrest in the usual way, as club cover did not extend to the disputed claim under the loan agreement. They said that they couldn't provide security in the form of a bond or guarantee, as their only asset, it was a one-ship owning company, was the ship, and it was fully mortgaged to the plaintiff bank. Owners said that they did not themselves have sufficient funds to effect a suitable security arrangement. Owners also contended that whilst under arrest, the vessel would lose gross hire of approximately $11,500 a day and a profit of between $3,500 and $4,000 a day. Owners said that they feared, quote, a potentially catastrophic loss, unquote, if the ship remained under arrest, as it would unless they could provide security under the usual practice, as it was their only income-producing asset and it was not in operation. As I said, in those circumstances, owners applied to the court for the release of the ship from arrest without offering any security, which would normally be the case. That is, the offer of security would normally be the case. In particular, the owners applied to the court for an order that the ship be released from arrest unless the bank provided a cross-undertaking in damages in the form usually given in the context of a freezing order, namely that if the court later finds that the warrant of arrest has caused loss to the ship owner and decides that the ship owner should be compensated for the loss, the bank will comply with any order that the court may make. In other words, the order sought by the owners, if made and if the undertaking had been provided, would have resulted in the ship remaining under arrest, owners continuing to suffer the losses that they were complaining about, but that said, would have been protected by the undertaking in the event that the bank's claim was ultimately unsuccessful, as the owners contended. Of course, if the bank declined or failed to provide the undertaking, then the vessel would be released from arrest. The owners would be able to resume trading with it and would not suffer any loss. Unsurprisingly, the bank opposed owners' application, saying that it would be contrary to court practice first to require the cross undertaking sought by owners to be given by the bank as a plaintiff in the context of an admiralty action, and secondly, to order the release of the vessel from arrest save on terms that alternate security is given in place of the vessel. Owners' application was dismissed by Justice Tier for reasons set out in what the Court of Appeal described as, quote, an impressive judgment. In conclusion, at paragraph 57 of the judgment, Justice Tier said, the court is unable to accede to the application that the vessel be released in the event that the bank fails to provide a cross undertaking in damages. To exercise the court's discretion to release in that way would, one, run counter to the principle that a claimant in rem may arrest as of right, two, be inconsistent with the court's long-standing practice that such a cross undertaking is not required, and three, be contrary to decisions of the Court of Appeal in two cases to which Justice Tier felt as a first instance judge he must respect. Justice Tier went on to say, finally, any change in admiralty law and practice, given that the present position has prevailed for so long, is not a matter for the court to change overnight, even assuming that it could do so, but for Parliament or the Rules Committee to consider after proper consultation. Owners appealed to the English Court of Appeal, but their appeal was dismissed unanimously for reasons set out in a joint judgment of the Court of Appeal, which, interestingly, judgment expressly noted that each of the three members of the Court of Appeal had substantially contributed to it. I don't know if the reason for that notation was that that's because that's not what usually happens. The Court of Appeal comprised the then Master of the Rolls, Sir Terence Etherton, and Lord Justices Gross and Flow, the latter two having had strong admiralty practices at the bar in England. Indeed, were barristers that I had briefed back in the 80s when I worked there. The Court of Appeal was well aware of the significance of what it was being asked to do by owners in making the order that the owners sought. Paragraph 5 of the judgment, the court said, as will at once be appreciated, and though neither is directly an issue, still less challenged on appeal, owner's case necessarily impinges on, one, the availability of a warrant of arrest as of right, rather than as a matter of discretion, and two, well-established authority to the effect that no damages are recoverable for wrongful arrest, that is under English law, absent either malice or bad faith or gross negligence in modern parlance. If owner's case is well-founded, there can no doubt be that both 1 and 2 above would be undermined. By itself, that is not conclusive, but it's important to be clear as to the potential ramifications of success for owners on this appeal, very likely extending beyond this jurisdiction, given the international nature of the maritime industry and the interest there would be in the course adopted by the English law. After noting at paragraph 93 of their judgment that it did not lose sight of the fact that alternate security by way of a P&I Club letter of undertaking was not available in respect of the dispute under a loan agreement because such a dispute is not covered by the relevant liability insurance, that is to say, the usual practice of provision of security through a letter of undertaking did not apply in this particular case. The Court of Appeal nevertheless went on to conclude at paragraph 94 that, quote, the case against an overnight change, to adopt the language of Justice Tier, to the settled law and practice is overwhelming. Interestingly, the ship owner's application was not a direct challenge to that settled practice, although it perhaps could have been. Rather, it was couched as an application to depart from that settled practice in the exercise of what the Court of Appeal found as the court's undoubted discretion having regard in relation to the release of a ship from arrest, having regard to, according to the ship owners, the particular facts of the case and their contention that they were an exception. In that regard, the Court of Appeal went on to say, again in paragraph 94 of their judgment, we remind ourselves in any event that this is an appeal against a discretionary decision by the judge, adopting counsel for the bank's powerful submission that there is no case for this court to intervene on a discretionary matter when on completely standard facts, the judge has followed his usual practice. In full agreement with the judge's conclusion, we would dismiss the appeal. The characterisation of the facts of the case as, quote, completely standard facts, or as the Court of Appeal said elsewhere, unremarkable, might seem to be a little surprising given the circumstances that I've outlined, albeit briefly earlier. Professor Davies has suggested that if ever there was a case for a ship owner to seek the relief that was sought here, this was it. But having said that, neither Justice Tier or the Court of Appeal thought that such relief should be ordered. But what flows from the Court of Appeal's earlier conclusion as to the overwhelming, that the case against an overnight change was overwhelming, appears to have been a concern that even the exceptional exercise of the court's undoubted discretion in relation to ordering the arrest of a ship from release, and thereby departure from the usual practice that was sought by the ship owner, would bring about a change to the settled law and practice which the Court of Appeal thought was unwarranted, and for reasons that I'll address later, thought was inimical to the value of arrest as a remedy. Despite the outcome in the Alkeon, the question that might be asked is whether there is need for reform in Australia. And essentially, two arguments have been advanced in support of the call for reform. The first is the similarity between maritime arrest and freezing orders, or Mariva injunctions, as I still like to think of them, yet the disparity in the circumstances required to obtain each, especially as to the need or otherwise of the giving of an undertaking as to damages. The second reason is a concern that the circumstances in which damages for wrongful arrest are recoverable are too narrow, and that the balance is too much in favour of the plaintiff. This is a concern, admittedly, that is primarily directed at the position in England, where the test for wrongful arrest is the common law test that I referred to earlier, requiring malice or gross negligence. The position in Australia is modified by Section 34 of the Admiralty Act, which is not a restatement of the common law test, and somewhere which is perhaps more favourable to the ship owner than the common law test, but certainly not as favourable as the usual undertaking, being the position that would be extracted from an applicant for a freezing order. I propose to concentrate on the first of those two issues, although if time permits, I'll comment briefly on the second. In relation to the first reason, those propounding reform emphasise the similarity between maritime arrest and the freezing order, and in particular the fact that both remedies seek to preserve the assets of a person ultimately liable for the plaintiff's claim, so that the hoped for judgment in the proceedings may eventually be executed against those assets. Historically, there are two incidents associated with, or two purposes associated with the exercise of Admiralty jurisdiction. They were identified by Justice Tier in paragraph 14 of his judgment in the Alkeon. The first pertains to jurisdiction, the second pertains to security. In relation to the first, the mere presence of the ship or the raise within the territorial geographical jurisdiction of the court is of itself sufficient to give the court jurisdiction to entertain and adjudicate upon the substantive claim that is the subject of that in rem proceeding. Moreover, this is so even if the ship, the ship owner, and or the plaintiff, and or the substantive claim itself have no connection with that jurisdiction, or in the case of the Australian courts in connection with Australia, see Section 5 of the Admiralty Act. This ability to pursue a maritime claim beyond the jurisdiction in which it arose and or to which the ship owner is amenable, potentially around the world, addresses what Justice Rares has described on more than one occasion as the peripatetic nature of ships and the potential difficulties that this presents for the recovery of a claim. This is in contrast to the Mariva injunction or the freezing order, where the mere presence of the asset to be restrained within the geographical or territorial jurisdiction of the court is not of itself sufficient to confer upon that court jurisdiction to grant such an injunction or make such an order, at least where the underlying substantive claim or the defendant, the subject of that claim, otherwise is not present in the jurisdiction or has no connection with the jurisdiction. The second purpose for arrest is that of obtaining security. As Justice Tier described, by arresting the ship, the claimant also obtains the means by which he can enforce his claim in the event that he establishes his claim. The ship may be sold by the Admiralty Marshal upon the order of the court, and the claimant may recover his claim from the proceeds of sale In that way, an arrest provides security for the claim in rem. In that sense, it is the ship itself which is the security. But as we all know, more often than not, an application is made for the ship to be released from arrest. And as a precondition to that application, alternate security is proffered. In those circumstances, it is that alternative security, which is the security that the arrest achieves. A security which is arguably potentially more advantageous to the ship because it comes from a third party, usually of some solid financial backing. At least one is not required to worry about the financial backing of the ship owner. And it's a security which no other creditor of the ship owner is generally able to access or have recourse to. Since the late 18th century, as the Court of Appeal noted, the arrest of a ship is no longer a precondition to securing jurisdiction in an action in rem, and that's certainly the position in Australia. One needs only to serve the writ in rem. Accordingly, the security benefits of maritime arrest now have greater prominence than they did prior to then, especially as a reason for arrest. Hence, those that draw the analogy with the freezing order. But for some, this emphasis upon maritime arrest providing security only serves to accentuate the disparity in the preconditions to arrest, the disparity in the preconditions to arrest with the preconditions to an application for a freezing order. In particular, where a ship may be arrested and security obtained without the plaintiff having to give any undertaking as to damages, albeit that the plaintiff is subject to a potential liability for wrongful arrest, whereas preservation of assets by a freezing order cannot be actioned without the applicant for that relief giving an undertaking as to damages, or in Australia what's described as the usual undertaking, being an undertaking which potentially gives rise to a liability that is broader and more adverse to the plaintiff than the potential liability of the in rem claimant for wrongful arrest. Given the similarities between these two remedies, the question posed is, well, why are there differing preconditions to the granting of this relief? And perhaps more relevantly, is that difference still justified? One possible answer is to paraphrase the title to Lord Mustall's address to the British Maritime Law Association in 1992, albeit in the context of ship limitation, namely, well, ships are different. But whilst that may be an acceptable and understandable response to the Admiralty lawyer, if there be such a beast, it's unlikely to be acceptable or understandable to the commercial or equity lawyer. One of the reasons for this difference in preconditions is the different historical origins of the two remedies. Arrest has grown out of the development of the jurisdiction and practices of the UK Admiralty Court with its continuation of civil law undertones. The freezing order is an equitable and discretionary remedy. But having different origins is not necessarily of itself a reason to maintain any difference between the two remedies if they are now more closely aligned and if the reasons that previously explained the differences no longer apply. For example, in Australia and England, a plaintiff applying ex parte for the arrest of a ship is subject to a more limited duty of disclosure to the court than the duty of full and frank disclosure required of a person applying ex parte for a freezing order. However, in Singapore and Hong Kong, an applicant for an arrest warrant is subject to that fuller duty of more onerous duty of full and frank disclosure. In this, albeit limited respect, the two remedies have at least aligned, and one might ask rhetorically, well, why can't the same be done in relation to an undertaking? But whilst there are similarities between maritime arrest and a freezing order, there are also significant differences between the two remedies. These are identified and considered in the ALRC report number 33, the report that preceded the enactment of the Admiralty Act at paragraph 245. Time doesn't permit me to list them all or to discuss them all. But relevantly, for present purposes anyway, they include the fact that arrest confers upon a plaintiff's security over the raise, even if it's confined to the arrested ship, which a freezing order does not do. It merely preserves the asset for later enforcement against the action. That difference and the consequence of arrest, as a result of that difference, arrest is seen as the more superior remedy of the two, at least in that regard. But some might question whether that difference is itself sufficient to justify either the maintenance of a differing approach to these two remedies, so far as any requirement or otherwise of an undertaking as to damages is concerned, or whether it justifies not requiring a plaintiff seeking arrest to not have to give such an undertaking. Indeed, some might ask, again rhetorically, why the undertaking as to damages is required for the lesser remedy, which confers no security, but not required for the more superior remedy, which does confer security. Although the answer to that may be that the arrest of a ship does not of itself confer security on the plaintiff, as opposed to merely perfects an existing but inchoate security that has already attached itself to the hull of the ship under Admiralty law, either upon the occurrence of the event that gives rise to the liability of the plaintiff in the case of a claim which is a maritime lien, or upon the commencement of the action in rem in the case of a claim that is a statutory right of action in rem, and which security interest therefore arises quite independently of any circumstances in which an undertaking might be thought needed or appropriate. That leads to another important difference between maritime arrest and freezing orders that is often pointed to, in particular as justifying the difference between the preconditions to their remedy, namely that subject to compliance with in Australia with the requirements of the Admiralty Act and the rules, a plaintiff in an action in rem against a ship is entitled to arrest that ship in the action as of right. The application is not normally made to a judge in court. It doesn't usually require or demand a favourable exercise of the court's discretion. The documents are filed with the registry and assessed by the registrar. Subject to compliance with the rules, the registrar has no real discretion to refuse the application for the issue of an arrest warrant or to enforce or execute the arrest warrant, absent perhaps an indication of obvious abuse. There is no assessment of the strength of the plaintiff's claim in determining whether or not the arrest warrant should be issued, nor is there any need to identify or assess any likely defence. On the other hand, the freezing order is a discretionary remedy. It requires a consideration of the prospects of the plaintiff or the strength of the plaintiff's claim. It requires disclosure of all of the matters that might go against that claim, such as the defence, and importantly, it requires circumstances that would warrant the exercise of the court's discretion, such as the imminent departure of the assets or their dissipation. I mean, in those circumstances, it might be said that whereas a plaintiff has an entitlement to arrest a ship in the action in rem as of right, and the law expressly provides for a remedy for the consequence of wrongful arrest or unjustified arrest as is described in Australia, which is not the case for a freezing order, absent the giving of the usual undertaking, it might be thought that there is no place or role for the imposition now of some additional requirement upon the applicant for arrest, and in particular a requirement that the applicant also give an undertaking as to damages either to effect or maintain that arrest. In other words, the imposition of an obligation upon an applicant for a freezing order to give an undertaking as to damages is to meet the effects of the court's order that the applicant seeks from the court and has persuaded the court to issue in its discretion in circumstances where, but for the undertaking as to damages, that any defendant or third party adversely affected by the court's order would have no remedy. In contrast, it might be said that the plaintiff applying for the arrest of a ship is exercising an entitlement that, although implemented by the court, the plaintiff has as of right, arguably in respect of its pre-existing but inchoate security interest, and where the law already provides a potential remedy for wrongful arrest, or at least already defines the circumstances in which a plaintiff exercising that right is or may be liable for the consequences of that arrest if it's wrongful or justified. In those circumstances, arguably, the extraction of an undertaking as to damages is not required in the case of arrest, and the analogy with the obtaining of a freezing order is not apt, or at least so the argument would go. The opponents of the above view point to the perceived or claimed inadequacies of the remedy for wrongful arrest, and in particular the narrow circumstances in which it's available, especially if compared to the circumstances in which an applicant for a freezing order may be liable under the undertaking they're required to give, as the foundation for reform, and more particularly for therefore more closely aligning the potential liability of the applicant for arrest with that for the applicant of the freezing order. That is, of course, directed to the second of the two reasons that I'd earlier identified, namely the perceived inadequacy of the remedy of damages for wrongful arrest, and in which, at least in my opinion, ought to be considered on its own merits and as a standalone consideration. If there is a warrant or a need for remedying that remedy because it is deficient, then the remedy should be amended accordingly. This is especially so, one would suggest, in Australia, where the remedy for damages for wrongful arrest is enshrined in a statute, unlike the English, where it's laid down in the common law. It's not the role of the court to simply disregard the statute or determine that there should be some other measure, although the court has the opportunity to interpret the statute and may interpret it in a pro-shipowner or pro-plaintiff way. But also, if the perception is a problem with that remedy, then it should be addressed squarely and should not be, so the argument would go, sought to be addressed in effect as a side wind by the imposition of an undertaking which is inconsistent with what the law otherwise sets down as the remedy for wrongful arrest. And yet that is in part the effect of what the proponents argue. Of course, if and I'm really dealing with the second ground now, if on a reconsideration of that remedy, the Parliament decided that it was or ought to be corrected and brought in line with, for example, the usual undertaking, and Section 34 was amended, there would then be no need for the usual undertaking because it would do nothing more than simply reflect the existing law. Equally, if the Parliament decided that there was no need to alter the measure of damages for wrongful arrest and that the existing measure in Australia should continue, then that would seem, at least to me, to be a strong reason why a court should not, either as a matter of discretion or as a matter of general practice or an exception to the general practice, impose upon a plaintiff an obligation, an undertaking which potentially has a liability which is greater than that for wrongful arrest. And that's the issue. To the extent that those complain about the perceived inadequacy of the remedy of damages, that's still an argument that seeks to contrast at least one respect of the two remedies and the way in which they differ, namely the potential liability for the consequences of the remedy if wrongly issued or the plaintiff claims. Sir Beirne admittedly takes issue with what I've just put. He says that, he has suggested that it's because of the inadequacy of the protection that the law gives to those subjected to their right to arrest that warrants the imposition of a requirement that the arresting party give an undertaking as to damages, in the same way that it is the inadequacy of the law in that it gives little or no protection to those affected by a freezing order, that it warrants the imposition of such an undertaking in those circumstances. But as I say, it seems to be a suggestion that equity should override, by imposing an undertaking, what the law, and in case of Australia, a statute otherwise provides. Sir Beirne's response to reliance upon the right to arrest argument as maintaining the status quo, he suggests has a superficial attraction, but nevertheless numerous flaws. First, he says that the right to arrest is not some immutable grand normal of Admiralty practice, and in the UK is a product of the 1986 rule change. That being so, there's no reason why the rules cannot be changed to reflect the requirement to give undertaking, especially if the position is, as Sir Beirne contends, otherwise unjust. There is, after all, an undertaking as to the marshal's cost, given in Australia by the plaintiff's solicitors, although that, of course, is an undertaking to protect the court. The question that is asked, well, why shouldn't the defendant also get such an undertaking? But Sir Beirne also said that even if the original arrest was as of right, there's no reason why the court cannot, in an appropriate or proper case, require an undertaking in order to maintain the arrest. And indeed, that was the genesis of the application that was made in the Alkeon. The comparison between arrest and freezing order was, as I said, considered by the Australian Law Reform Commission report, in particular paragraph 245. I don't as I said, I don't propose to deal or repeat or deal with that discussion. That's because in that regard, the Commission's focus was more in the context of whether there was any need for reform of Admiralty law in circumstances where freezing orders or Mariva injunctions, as they were then known, might also be available for maritime claims, and recognising that there was some overlap between these two remedies as well as many differences. The Law Reform Commission concluded that there was no international consensus on restricting detention of ships, including by Mariva injunctions to maritime claims, and that injunctions or freezing orders in addition to the action in rem and arrest should be allowed, and the issue of their availability left to the courts. But in acknowledging the continuing role of maritime arrests, the Commission did not expressly consider the issue at hand here, namely whether the precondition to the exercise of the right to arrest a ship in an action in rem should include or be amended to include the requirement that the applicant give an undertaking as to damages in the same way as the applicant for a freezing order. However, one might infer from a reading of the report that the Commission is unlikely to have made such a recommendation had it turned its mind to it. That's not only from its discussion of the differences between these two remedies, but also its discussion of the reform of the circumstances in which damages for wrongful arrest may be recoverable, and no hint of a suggestion that that reform should extend to a liability analogous to that to the usual undertaking. The comparison of the maritime arrest and the freezing order and the call for reform was also squarely addressed by Justice Terre and the Court of Appeal in the Albion. Time doesn't really permit to deal with all of the issues that were raised, but let me just make a couple of observations to the extent to which they may offer some guidance as to what the position would be were this issue to arise here. Justice Terre, at first instance, had noted that, quote, judges of great authority had not been compelled by the comparison to suggest that a cross undertaking should be required in the context of a maritime arrest, unquote. Although one might question the force of such an argument that just because judges in the past hadn't thought of this reform, it should not be considered now, especially if there was now some justification or, as Sir Bernardita contended, there was now a recognised injustice. The Court of Appeal expressly recognised this question. It described it as a question that can be searchingly posed as to why the position of a party making a maritime arrest should continue to diverge from that of the claimant obtaining a freezing order. However, the court's response to that question was to conclude that the analogy between maritime arrest and a freezing order, quote, is neither exact nor compelling, close quote, adopting language of Professor Davies. In the end, this comparison and this neither exact nor compelling similarities of these two remedies were not enough to persuade the court to change the established settled Admiralty practice to bring them more in line with the position regarding freezing orders. Nor, it would appear, were these similarities enough to justify making the order sought by the shipowner in that case, even as an exception to the usual practice and in the exercise of the court's undoubted discretion to order, which it had in relation to making an order for the release of a ship from arrest. The Court of Appeal approached this appeal as one challenging the primary judge's exercise of the court's discretion in relation to the release of a ship from arrest and whether there had been an error in the exercise of that discretion. It was not treated as a challenge by the shipowner to the usual and settled law and practice by which the discretion was to be exercised. Nevertheless, one of the strong reasons given for upholding the primary judge's exercise of the discretion to refuse the shipowner's application for the imposition of a cross undertaking as a condition was the impact that acceding to that application was likely to have on settled law and practice, even as an exception to the usual practice. In this regard, the Court of Appeal found that there were, quote, formidable considerations that can properly be said to support the status quo and at least tell against it departing from existing law and practice in this regard. Indeed, the court identified 8 such considerations. I won't list them all, but they included that the fact that, according to the Court of Appeal, should owners' appeal succeed, it is, quote, overwhelmingly likely that the requirement of a cross undertaking would become routine, unquote. Accordingly to the Court of Appeal, there was nothing unusual about the facts of the case. As I said, it was described as unremarkable. And the court suggested that in those circumstances, if the requirement of a cross undertaking was ordered in this case, it was likely to result in the requirement of a cross undertaking being ordered routinely, and routinely becoming the price of arresting or maintaining an arrest. If that occurred, according to the court, quote, the stakes in any in rem action would become vertiginously high, unquote, again quoting Professor Davies, and which the court went on to suggest was bound to have a, quote, chilling effect, unquote, again quoting Professor Davies, and to constitute a deterrent to the use and threatened use of the right of arrest even in apparently meritorious cases. Accordingly, to this extent anyway, the argument against aligning these two remedies by requiring an undertaking as to damages appears to have rested on both the Court of Appeal's expected detrimental adverse consequences that the imposition of that requirement upon a plaintiff is likely to have on the practice of maritime law. Moreover, this was so even if it was imposed as an exception to the general rule and within the court's existing discretion. There are a number of other issues a number of other factors that the court pointed to in this regard, and I won't list them all here. They included that there was no real call, or at least the court concluded that there was a formidable inference, a powerful inference, that there was no significant pressure from the maritime industry for a change in the balance struck so long as between the ship owner on the one hand and the potential maritime claimants on the other. And that observation appears to extend not only to the requirement to the giving of an undertaking, but also in relation to the measure of damages for wrongful and the test for wrongful arrest. The court also suggested that there was no consensus internationally, although one might note that Article 6 of the 1999 Arrest Convention provides that a court may, as a condition of the arrest of a ship, or of permitting an arrest already effected to be maintained, impose upon the claimant who seeks to arrest or who has procured the arrest of the ship the obligation to provide security of a kind for an amount and upon such terms as may be determined by the court, in effect for what was the measure of damages under the convention. The convention doesn't impose an undertaking as such, it imposes security, and there are those such as Sir Bernardita that suggest that in addition to the undertaking, security should also be provided. And it was also security for the measure of damages for wrongful arrest, which is a different measure of damages to that dealt with here. But the notion of security and presumably an undertaking that might otherwise support it is not unknown to the law. Although that said, the convention has not been widely followed and that provision has not been widely adopted. Justice Tamblyn, in the paper that I referred to earlier, addressed Article 6 and described it as the provision as in effect providing for not only an undertaking as to damages, which is currently not required under the Act, but also requires security against losses, direct or indirect, which the defendant may suffer. His Honour's comments were a function of both the different measure of damages for wrongful arrest as well as the requirement of security. His Honour, consistent with what the Court of Appeal had suggested in the Alkion, went on to say that this will be seen by claimants, at least in civil law jurisdictions, as weakening the efficiency of the arrest process and could impact on the attractiveness of the arrest machinery. His Honour also queried how such security could be sought at the time of arrest and in the absence of evidence of the likely costs of the consequences of the particular arrest, and went on to say, from a practical point of view, the requirement to provide counter-security could lead to a protracted initial litigation in a context where the eventual amount of damages is entirely speculative. The same might also be said in the context of the application for an undertaking. In essence, can I just say that in relation to the Court of Appeal's judgment, that the court did not seem to be particularly persuaded that there were these similarities between the relief injunction and the freezing order, and certainly were not persuaded that those similarities were such as to warrant the imposition of a undertaking as to damages, not only as a part of the usual practice, but indeed as an exception to the usual practice. And the latter appears to be on the basis that if it was introduced as an exception to the usual practice, it would then become part of the usual practice. And that opened the floodgates, if I could use that expression, from the Court of Appeal. And whereas Sir Bernard Eder describes the injustice between the two positions, an injustice which the Court of Appeal perhaps answered by saying, well, no one's been complaining about it and no judges have thought it was useful. But while Sir Bernard talks about that injustice, the Court of Appeal's focus is what the effect of imposing that undertaking would be upon the efficacy of the arrest warrant and on those maritime claimants that are dependent upon the arrest warrant. As Justice Verey said, the peripatetic nature of the ships, the claimants follow the ships around the world. And the concern was that if such an undertaking were required, that would result in a lessening of the use of that remedy. To the extent that this first reason might therefore be advanced as a basis for reform in Australia, the question, I suppose, is whether an Australian court is likely to come to any different conclusion to that of the Court of Appeal in the Alkyon, and especially whether the Australian court would come perhaps to a different conclusion in relation to whether even allowing for a cross undertaking as an exception would necessarily result in a substantive change. I've already touched on the second reason. I don't propose to say anything more about that. Can I make two final observations dealing with the issue as to how such reform might be implemented? And they're observations really just to leave the question open perhaps to the audience. The first is that if there was to be reform by the imposition of an undertaking as to damages, and it was to be reform of the usual practice, then it seems, at least to me, that almost certainly that would have to be implemented not by any decisions of the court or through the courts, but by amendment to the rules and by the legislature, in particular amendment to the Admiralty rules. That's not to say that the existing position could not be maintained. It still could. The applications could still be lodged with the registrar. There could still be an entitlement as of right. There could still be the limited disclosure. And if the documents were in order, the arrest could follow. But if it was thought that it was appropriate to give an undertaking, then the rules could simply adopt the same procedure or approach they do with Rule 41 and the solicitor's undertaking as to damages, and simply deem that upon the application being filed, then the undertaking is given. Of course, that begs the question as to then what is the terms of the undertaking. If the terms of the undertaking is no more than a reflection of the liability for the damages of wrongful arrest, it's probably not really worth that much more. And there are issues about the utility of enforcing that undertaking against foreign plaintiffs who are commonly following the ships seeking to enforce their claim. Even if it's an undertaking to the court, which can be enforceable by contempt and sequestration of assets, that's of limited utility in circumstances where the foreign plaintiff has no assets in the jurisdiction. There is the suggestion that if such an undertaking were given, it could be secured in the context of a foreign plaintiff, in more or less along the lines of Article 6 of the 1990 Convention, although there is dicta of Dr. Lushington and the DP something or other, which suggests where Dr. Lushington said that a foreign plaintiff should certainly provide security for costs of an arrest proceeding, but shouldn't provide security for the damages for wrongful arrest. The second observation is, in the absence of a change to the current practice, could the application that was made in the Alkyon be made in Australia, that is, as an exception to the existing practice? And in that regard, Australian courts have power to order the release of a ship under Rule 52 of the Admiralty rules. Unlike a release by a registrar under Rule 51, there's no specification within Rule 52 of the circumstances in which release may be ordered or refused. There's no express requirement that the court can only release a ship upon provision of adequate or alternate security, contrary to Rule 51. And there's no express provision prohibiting or preventing the release of a ship from arrest on condition, including a condition which, if satisfied, prevents the release, such as the order that was sought in the Alkyon. Indeed, Rule 52.3 expressly provides that on an application under Sub-Rule 1, the court may order the release of the ship and property on such terms as are just. But one might then ask whether an order of the type sought in the Alkyon is in fact a condition of release or a conditional release. You'll recall the order was that the ship be released unless the undertaking is given. If the undertaking is given, the ship remains under arrest. In one sense, such an order might be more in the nature of imposing a condition of the maintenance of the arrest rather than a condition of release. And it might be suggested that Rule 52 is not directed, or the language of Rule 52 is not directed at that position. I express no concluded view on that issue. In the finest traditions of the bar, I'm open to arguing either side. But if the relief, such as that sought in the Alkyon, is within the discretion otherwise found in Rule 52, and the court has power to make an order of the type sought in the Alkyon, then the critical question, and perhaps the most controversial question, is whether the facts of the particular case are sufficient to displace the otherwise usual practice that a ship will only be released upon provision of security, or perhaps what facts are required in order to result in the favourable exercise of that discretion. As I said, Professor Davies has said, in the Alkyon, in circumstances where one has some sympathy with the owners, who in effect had to put up security for the entire of the loan, which they clearly couldn't provide, were prevented from either avoiding the damage that they would otherwise suffer. The ship was under arrest, or at least getting their ship back in circumstances where, or getting some protection in that regard, or otherwise getting the ship back if the protection wasn't provided. The question is whether an Australian court would be more adventurous than the Court of Appeal of Justice Terre and order a undertaking in those circumstances. Finally, I should say the postscript to the Alkyon was that after the Court of Appeal's judgment, it didn't go any further, it didn't go to the Supreme Court. Owners, perhaps unsurprisingly, took no further role in the case. A default judgment was entered for the full value of the loan. The ship was sold under a judicial sale of the order of 12 million US, which was less than the loan. So the owners were still on the hook, such as the One Ship Company was for the balance of the loan. And the ship was renamed and no doubt is still sailing on the seven seas, hoping not to be arrested again. Thank you.
Well, thank you, Geoffrey, for that lucid and interesting talk. You've convinced me in 40 minutes or so what no one has managed in nearly 40 years to, which is that I need to know more about maritime law. So thank you about that. Well, that really draws the evening to the close, the Richard Cooper Memorial Lecture for 2022.